Thank you, Chairman Goodlatte. The Chair now recognize the distinguished gentleman from Michigan, Mr. John Conyers, the ranking member on the Committee on Judiciary, for his statement.
Thank you, Chairman. The Satellite Television Extension and Localism Act is full of options that we have witnesses to distinguish. I want to thank the chairman for keeping the witness list down to 7. I understand we ran out of tables and we weren't able to put on any more people than are here. I want to consider these options, and I look forward to the witness testimony. Two considerations, one about copyright owners and the other about consumers. We must protect copyright owners because it's their property that forms the basis of the entire scheme. Compulsory licenses are generally not favored because they distort the marketplace and result in below market rates being paid to content owners. Second, we must enact policies that protect consumers and safeguard competition. Consumers benefit from increased competition because more competition usually produces lower prices. And copyright owners do not benefit financially from retransmission consent agreements, which is at the heart of these disputes, despite the fact that the signal only has worth because of the programming contained on the signal. And so I think we must focus on principles of localism. People who subscribe to cable or satellite television have so many options, there's never a shortage of something to watch. But even with all these choices, people still highly value their local news, their local sports, and need local channels to deliver community service and emergency information. Localism and the traditional network affiliate relationship also benefits copyright owners by allowing their programming to be publicly performed in every market across the country. Now, I conclude by observing that there will be circumstances in which these principles will conflict. I look forward to working to ensure that the public interest can best be served through satellite carriage of broadcast television signals. And I thank the chairman for allowing me to make these few brief remarks.
Thank you, Mr. Conyers. I appreciate that.
Thank you very much. Could I begin our discussion? And I thank you for the variety of views presented. But do you believe, Mr. Dodge and Mr. Patton, that Congress should do more than simply reauthorize the distant signal license? Well, Mr. Dodge and Mr. Patton, do I sense that there is a little space between both your responses?
Yes, although we are good friends.
Oh, we're all friends here. Now, I'm going to give you another chance, Mr. Dodge. What are the targeted fixes that the American Television Alliance, ATVA, is calling for to the retransmission consent rules as part of the Stella reauthorization? Thank you, Chairman Coble. Thank you, Chairman Goodlatte.
Let me make sure that
This, as been a very important hearing, and I wanted to begin by asking Professor Martin about a decision by Justice Alito, a 5-4 decision as usual, who dismissed a number of groups for a lack of standing, reasoning that respondents can't manufacture standing by choosing to make expenditures. Is the harm alleged by, among others, Amnesty International and ACLU, hypothetical, which was the basis of this conservative decision? Could I ask?
My colleagues are successful.
Can I ask Mr. Jaffer? In addition to your 4 recommendations, is there a way that we can reconcile our concern against terrorism and at the same time permit the largest usefulness of privacy possible? You know, after all, if it hadn't been for a couple people leaking, we wouldn't have known about any of this, as far as I'm concerned. Some say that somebody made a statement on the floor of the House. If you happen to have caught it, you could go back and track it. But I think I'm more concerned about the collection legality than I am about the uses to which it is put. And more chilling now than anything is the fact that they've got information through phone numbers, which can easily be attached to names, of everybody in the country for at least 6 years. And that is probably the most disturbing aspect of this matter to me that I've been hearing today. Thank you very much. Thank you, Chairman Goodlatte, members of the committee. We on Judiciary, which is the committee of primary jurisdiction for both of the authorities we're here to discuss today, Section 215 of the Patriot Act and Section 702 of the FISA Amendments Act. Over the past decade, the members of this committee have vigorously debated the proper balance between our safety and our constitutional right to privacy. And so I join in welcoming the 2 panels, 4 each, very fairly made up, to this discussion today. I think it's an important one. But we never at any point during this debate have approved the type of unchecked, sweeping surveillance of United States citizens employed by our government in the name of fighting the war on terrorism. Section 215 authorizes the government to obtain certain business records only if it can show to the FISA court that the records are relevant to an ongoing national security investigation. Now, what we think we have here is a situation in which if the government cannot provide a clear public explanation for how its program is consistent with the statute, then it must stop collecting this information immediately. And so this metadata problem to me, has gotten quite far out of hand, even given the seriousness of the problems that surrounded and created its need. Now, I have another concern that pertains to the administration's track record of responding to the criticisms of these programs. We know Director Clapper's misstatements and others. National Security Agency Director General Keith Alexander had to make retractions. Even FBI Director Robert Mueller is not empowered to rewrite history. But what we have is our conversation, which requires focusing on improving both more public scrutiny and congressional oversight of these programs. Over the last weeks, the administration has asserted that its conduct of this surveillance with congressional support, because they've briefed some members of these programs in the past. But that is not sufficient, since we're in a catch-22 situation in a classified briefing in a secure setting, and we cannot discuss it publicly, certainly not even with our constituents. But if we skip the briefing, we risk being uninformed and unprepared. One simple solution to this problem would be to publicly release significant FISA court opinions, or at the very least, unclassified summaries of these opinions. This solution would have the added benefit of subjecting the government's legal claims to much-needed public scrutiny. And over the past decade, the court has developed a body of law that instructs the government about what it may do with the information it collects. There's no legitimate reason to keep this legal analysis from public interest any longer. And if we are to strike the right balance with these surveillance authorities, which I think is an important purpose of the hearing today, then we must bring the public into the conversation as soon as it's appropriate and without delay. And I am not talking about releasing any classified information. Instead, I'm simply asking our constituents to trust us, as I am asking you and the executive branch to trust them. And the need for more declassification, I think, is very dominant in my opinion as to how we should move this today. And I thank the chair.
Thank you, Chairman Goodlatte. There is a couple of questions here that haven't come up. And I'd like to direct them to Attorney Douglas. If only relevant conversations can be secured under Section 215 of the Patriot Act, then why on earth would we find now that we are collecting the names of everybody in the United States of America who made any calls for the last 6 years or more? Well, how do you consider that to be relevant to anything if there is just collecting only the names. And I mean, look, if this is an innocent pastime that we just do to keep busy or for some other reason, why on earth would we be collecting just the names, just the numbers of everybody in the United States of America for at least 6 years? Well, here we're faced with the fundamental problem in this hearing. We're not questioning access. We're talking about the collection in the first instance. In the first instance, when you collect the phone numbers of everybody in the United States for over 6 years, there wasn't anything relevant in those conversations. Now you have them, and what I've been getting out of this is that this access may become valuable, Mr. Ranking Member, and so that's why we do it this way. But I maintain that the Fourth Amendment, to be free from unreasonable search and seizure, means that this metadata collected in such a super aggregated fashion can amount to a Fourth Amendment violation before you do anything else. You've already violated the law as far as I am concerned. And that is, in my view, the problem. And of course, to help further document the first question that the chairman of this committee asked is, why didn't we just tell everybody about it? Is because the American people would be totally outraged, as they are getting now as they become familiar with this, that every phone number that they've ever called is already a matter of record, and we skip over whether the collection was a Fourth Amendment violation. We just say that the access proved in one case or two that it was very important, and that's why we did it this way. I see this as a complete failure to take in, we changed the Patriot Act to add relevancy as a standard because of this very same problem that has now been revealed to be existing. And so I feel very uncomfortable about using aggregated metadata on hundreds of millions of Americans, everybody, including every member of Congress and every citizen who has a phone in the United States of America. This is unsustainable, it's outrageous, and must be stopped immediately. We're handling this discussion. I ask her, maybe somebody else can do it, but my time has expired, and I appreciate your volunteering to help out here, but it's clear to me that we have a very serious violation of the law in which the Judiciary Committee deliberately put in the issue of relevance, and now you're going to help me out and defer to somebody else. Well,
no, sir, I meant to actually provide additional information. I'd be happy to take a question for the record if time is not allowing that.
Well, without objection, the gentleman is recognized for an additional minute to allow another member of the panel to answer the question if he so chooses.
No, I don't so choose. I'm satisfied exactly what I've gotten from the witness that I asked the question to.
The chair thanks the gentleman, and
You're welcome.
now recognize the gentleman from Wisconsin.